Good afternoon, everyone. We might make a start. It's a busy time for all of you, I know, but thank you for choosing to join us this afternoon as we go through the changes arising from the last set of negotiations for the Medical Scientists Agreement. Just before we start, just by way of acknowledgement, I'd like to acknowledge that wherever we meet today, we meet on Aboriginal lands, and for me, that's the land of the Bunurong people of the Kulin Nation, and we pay respects to elders past, present and emerging. If I could ask all of you just to ensure that your microphones are switched off, and that just prevents any background noise that might be there at your end from coming into the discussion today. Once upon a time, we used to do these things on a polycom. And the way that that would work is that if somebody was listening and went on hold, that everyone would hear the hold music. But lucky for all of us, things have changed and we get to use this technology now. But if you could keep an eye on your microphone and make sure that it is turned off, we'd appreciate it, unless you're speaking, of course. Having said that, at some point during today's presentation, somebody will begin speaking whilst on mute. And when that inevitably happens, feel free and confident to pepper the comments page with the words "you're on mute," and we'll make sure we highlight that when it comes to the video version of this.
Took me a month.
Sorry, just one moment.
But yeah, is that okay then if she into her?
So yes, if I could remind people just to put themselves on mute. I'll ask my colleagues just to do a quick scan to see if we have any live microphones. Just a reminder that today is being recorded. So today is not just a private discussion, it is recorded. It will be one that is then available to members. We do that with each Enterprise Agreement Implementation Forum. We have the session, we record it, so it's available to people who either want to see it again or couldn't make it today. And it must be acknowledged that for some of our members, there is a lot going on today, particularly in regional Victoria. Before we get started in terms of the changes, I'll just introduce myself. I'm Stuart McCullough, I'm the CEO of VHIA, but I'm joined today by Kopilas, a Senior Workplace Relations Consultant, and Madeleine White, Workplace Relations Consultant. I'm sure most of you will know both Maria and Maddie, but they'll also be taking you through parts of today's presentation. In terms of what we'll be covering today, we're going to talk about where you can find additional information and additional resources. We're going to recap the bargaining process. We're going to just briefly explain the agreement approval process so people know what to expect. And then we'll talk about the changes that have been made to the current agreement. And we'll be spending, obviously, the bulk of our time in that category. We'll also touch on a memorandum of understanding. It's not a term of the agreement, but it is something that sits alongside the agreement that does some other things. We've got question time there at the end, but we'll be stopping periodically as we go to see if anyone has questions. So there will be a chance to ask questions as we go through. I would strongly encourage people to utilise the chat function for that purpose as well. If you pop your question in there, we will go to it at some point during the proceedings. But yes, just a reminder to people if they could keep themselves on mute. All right, there will be more information. So the way people will get information through bulletins, podcasts. One of the things you may have noticed, we've started doing podcasts on key clauses for this agreement already. And we've been doing that really for the last sort of month and a half or so. There will be an implementation guide, an implementation tracker, and we'll also be providing updates through the VHIA EMA network. The podcasts will really be directed at going in depth on particular clauses. Those are available in video and audio format. The implementation guide provides a high-level checklist of all implementation requirements. The tracker will provide updates and implementation items that might need to be completed over the life of the agreement, and that's issued with the monthly IR report. And just a reminder that the EMA network is a way for us to communicate with you, you with us, and you with each other. So we'll just encourage you to utilise that technology. Just quickly to recap on bargaining, it started in August 2020. that is more than 2 years ago. There were 89 bargaining meetings concluding in September 2021. 89 bargaining meetings is the highest number of meetings for any agreement in the most recent round. By way of contrast, that compares to 23 for the nurses and midwives. That compares to 53 for doctors, and doctors was for 2 agreements, not for 1. A heads of agreement was reached in December 2021, and notwithstanding that there were 89 meetings, each of those bargaining meetings was summarised on Yammer. The reference group met at least weekly, and reference group meetings were also summarised. The heads of agreement was reached in December 2021, just before Christmas. There were some delays or challenges in drafting in terms of, and the parties continued to meet about the items within the heads of agreement. But I just would like to take this opportunity to thank everyone who participated in our reference group meeting. What we find with bargaining is where things run on schedule, like doctors and nurses, both of which were completed before the nominal expiry date, the level of engagement from members is really high. It's much harder where the bargaining is protracted, which was the experience here. But I'd like to thank those who stuck with the process, and there were many of you who did that. So thank you. During the course of negotiations, we did issue things, AIP documents, that is progressive bargaining documents, to let people know what had been agreed as we went, as well as high risk reports, which are really just reports that are directed to your CEO to identify those items that could have a significant financial or operational impact. In terms of where we're at, now that the agreement's been finalised, it's got to go through that Fair Work Commission approval process. We're in the process of going to ballot. From the 22nd of October to the 27th of October will be the ballot period. I think the ballot, that means the ballot opens on Saturday of this week. It will then be lodged on the following day, the 28th of October. The Fair Work Commission suggests that the process takes between 4 to 9 weeks, depending on complexity. I would say that this is a complex agreement. I think that's a fair assessment. It comes into operation 7 days after it is approved by the Fair Work Commission. And the approval date turns on when the agreement is lodged. Obviously, there'll be updates. One of the things, though, you can expect is that you'll get some material from us at the time of a successful ballot. That is material about how to start preparing payments. That's a change to our process at our end. Just from feedback from members, they're looking to get that material to make the preparations and give a bit more of a run-up to getting ready for payments, and with a view to, I guess, shortening the time before those payments are given effect to entitled employees. And I do want to just emphasise the difference between date of effect and date of implementation. So some payments are date specific, including wages and allowances, to 1 December 2021. Patients and bargaining payment, which is a back pay by another name, it reaches back to a period covering 1 July 21 to 30 November 21. And whilst they cover periods before the agreement comes into operation, they're to be implemented once the agreement takes effect, once it comes into operation. That brings us to the changes that have been made to this agreement. So part 1, operation of the agreement, covering coverage, commencement date and definitions. So it covers those employees who are listed in the schedule, and every person who's employed by any of those employees in that schedule, or those who are successors. And successors is a relevant thing in the sense of there is a lot of consolidation within public health. But for those who are eligible to be a member of the union and employed in any classification within the agreement. And the union may seek to be covered by the agreement, and we anticipate that they will. That would be the normal course. As we said before, the agreement comes into effect 7 days from the date of approval from the Fair Work Commission. Wages come into operation from the beginning of the first full pay period commencing on or after 1 December 21. and the nominal expiry date is 30 November 2025. Worth taking into account for a moment the nominal expiry date of the current agreement, which is late January 2021. And what you can see there is that really the period that we're covering is almost 5 years rather than 4. There are some changes to definitions, including some new definitions and some amended definitions. The HSR definition is new to this agreement, but is not new to our sector. The definition of HSR is consistent with the one found in other agreements. That term is used in a couple of spots of the agreement, so it is now the subject of the definition. Similarly, the OH&S Act is referred to a few times through the agreement, so that term is defined. Of particular interest, I think, is the definition for recognised prior service. So this was something that was unclear, and being clear is obviously something that's critical if you need to correctly classify someone. So on screen, it states how that definition is relevant. It's relevant to classifying employees to the correct increment, identifying the correct rate of personal leave accrual, qualifying for parental leave and sabbatical leave. And it means that if you have recognised prior service when starting a new job, you may have a higher rate of personal leave accrual than you otherwise would. You may qualify or have already qualified for parental leave and sabbatical leave. Looking at that list, and you're probably likely wondering whether any of that is new. The parties identified in the discussions something that might be described at worst as a gap, at the very best, a lack of clarity on this issue. So what this is seeking to do is to make that clear in the way that other agreements are clear on that point. Also, some definitions, an amended definition of scientist there, and an amended definition of service. In terms of service, that really goes hand in glove with the recognised prior service. And one of the gaps that the parties had identified is that the previous agreement had not directly recognised how service from one health service to another worked. It recognised service from community health centres, but not other hospitals as such. So that was obviously at a step with other agreements. That loop has been closed. Also by reference to section 22 of the Act, but it includes recognised prior service, and VHIA is also one of the definitions that's been included. In terms of dispute settling, part 2 covers dispute settling procedure, independent dispute resolution procedure, BPEC, performance management, and disciplinary procedure. In terms of the dispute settling procedures, many of the changes that are here reflect changes that have been made for other agreements. We will do a podcast on this particular clause. I think it's going to be podcast episode 248, a little bit later this year. But if you are keen to get your head around those changes, I would recommend episode 215, which discusses many of the same changes in the context of the nurses and midwives agreement. The change there to relevant supervisor in terms of allowing for dispute discussions to occur with the relevant supervisor is intended to provide more flexibility and reflects how it works in practice in all likelihood. It may not always be the line manager. It can be someone else. The option of conducting the process in writing, if agreed, with disputes, face-to-face interaction can be useful to test whether an issue can be resolved. But it's recognised that that's not always appropriate and not always necessary. So greater flexibility to the parties by agreement. And that point there about notifying the other party as soon as practicable of any non-compliance concerns, what that's directed to is reducing delay and avoiding delay that arises that if compliance concerns come up at the point that the parties are before the Commission, it's quite likely that the Commission will send the parties away to go and have their discussions. One of the key costs arising from dispute settlement procedures is delay. And anything that can be done to reduce delay is beneficial. So if somebody alerts the other to a non-compliance issue, that party has an opportunity to rectify it before it causes delay. The Independent Dispute Resolution Panel, this goes by a number of different names, but it is a new term for this agreement. So this kind of panel has been a feature of many, but not all agreements of this round. And at issue is whether an industry-based panel will prove a more efficient way for resolving certain types of disputes. Time will tell whether that's the case. In terms of, you'll see there at the top of the page, it talks about who was on the panel, and it talks about a nominee of the VHIA, a nominee of the union, and a chairperson. In terms of the nominees, they can and probably will vary from one dispute to the next. So it's not about nominating one person for the life of the agreement. It will move around because it might be that a particular occupational expertise is appropriate for that dispute. The other thing to draw your attention to is the limited scope of this particular panel. It really is limited to two things: classifications and clauses 33 and 34, which broadly speaking are workload matters. It does provide that a third item can be progressed, but only where an employer agrees, namely under payment of wages. The employer has an absolute discretion as to whether they agree to an underpayment of wages dispute being addressed through this mechanism, through the IDP. Again, we will be doing a podcast on this particular clause as episode 248. A best practice employment commitment, bad news for those of you who are fans of the SDPPWG, that is the Service Delivery Partnership Plan Working Group. It is no more, and it is replaced by the Best Practice Employment Commitment Committee. These are terms that are required in an agreement. So under the previous state government wages policy, there was a requirement for an SDPP. Under the current one, and there's a requirement for a BPAC. And really, it's a centralised committee of ourselves, VHIA, the union and the department. And the things that we'll be discussing are those on screen. So some interesting things there. There's a reference there to equity issues arising from flexible working arrangements. And some of you might recall the work we did with the ANMF about a best practice guide and a podcast on that. Gender equity activities, there's obviously a lot of interest in that, particularly with the release of the baseline report from the Commission for Gender Equality in the Public Sector on the 5th of September. Consolidation of major agreement provisions to reduce complexity and inefficiencies within the public health system. We're going to have another go at bringing all the different unions together to see if we can get greater efficiency across the agreements for non-occupation specific terms. The fact that we have up to 12 agreements applying in one site is a very complex environment for you to administer, and complexity is cost. If we can get consistency, at least on some of the procedural terms, that reduces that complexity and cost. One of the other things we're keen to do is develop template change impact statements with a view to making that process more efficient. There was an emphasis on an assessment measure for workload stress, but we'll be talking about that. Compliance with the agreement is a key feature. And climate change initiatives to reduce carbon and other harmful emissions within the public health system. For those of you who attended the recent briefing on the doctors' agreement will know that this has been a theme through bargaining where unions are raising that issue of climate change. And I just made the observation that there is an opportunity for engagement on those subjects in that health services are very active in this space. But what we found is that whilst the health services are very active, both in what they do and what they publish, there's not a high level of awareness with some of our union stakeholders as to those activities. So there is a way to sort of bring that together and have some, what I hope are constructive discussions. And working from home, including emerging standards. Obviously, if you're negotiating at a time when there's a pandemic and a lot of people are working from home, it raises that question as to how should that work? How should that function? And we can anticipate that the standards will emerge as people look back over the last 2.5 years or so. And the BPAC will be in a place for discussions about those. Moving to performance management, this is an existing term that has been amended, and the amendments are reasonably modest. And it includes a description of what performance management is and what it isn't. So the existing clause has been amended to describe what it is, including its purpose, but it's a process of supporting an employee who's not performing all or part of their job to a standard of performance reasonably expected by the employer. It includes reasonable actions to address underperformance by identifying performance deficits, the employer's expected outcomes and performance measures, strategies to meet those measures, including support, training and education an employee may reasonably require. And performance management is not underperformance, it's not misconduct. There is a line at which it crosses over, but this clause, so just in terms of that question that Prue asks, does this apply to PIPs? So PIPs are a tool that we would see as applying to performance management. There's some unique aspects to this clause that I'll come to shortly. There is additional detail in the amended clause regarding the possible outcomes, including a performance management plan, the PIP, counselling the employee, and advice on file. What's unique about the clause and what has changed is that the performance management term provides an avenue to termination of employment in certain circumstances. And those circumstances are after making a reasonable effort and the other conditions on screen complied with the clause, valid reason, not harsh or unjust or unreasonable. That is something that's wholly unique to this agreement. And the perspective seemed to be that performance management and discipline were separate processes. And I'm aware there were some instances where it was disputed that you could discipline someone for a performance issue. In terms of resolving that, it's resulted in a change to the performance management clause that leads to, in significant circumstances, I guess, an opportunity to bring the employment to an end if those performance issues cannot be resolved. In terms of the disciplinary procedure, a lot of the changes here will be familiar to you. Particularly, employees can waive the need for an investigation where the concern is undisputed, while still raising matters of mitigation before a sanction, if any, is decided. The employer is to provide an employee reasonable time to provide information and mitigation. The exclusion of those yet to complete a minimum employment period, or a probationary period as it used to be called, from a three-step discipline process, but procedural fairness still applies. That's been a common outcome across agreements, and a requirement that employers act on conduct or performance issues as soon as reasonably practicable after becoming aware of the issue. And what that's intended to prevent is people storing up issues that they're aware of and putting them all at once. If you become aware of something, you raise it at the time. That's not to say that if you become aware of something at a later time that you're prevented from raising it. It's when you're aware that is the key point, rather than when something happened. So the key point there is that the changes here are similar to those in other health agreements. And if you are keen for some more information about those general changes, we'd recommend podcast episode 218. It concerns nurses and midwives, but it covers a lot of the same territory. Right, part 3, union rights. Unsurprisingly, this part covers union rights. So our quest to rename this clause union rights and wrongs was ultimately unsuccessful. But mostly this clause is the status quo. The changes are predominantly centred on the Workplace Implementation Committee, which existed under the previous agreement but now has a new name, the Workplace Implementation and Compliance Committee. And there's more an express focus on implementation and compliance. In terms of that compliance requirement that's there on screen, and you'll see it in the middle of the screen, that within 3 months of the agreement coming into operation, provide union plan for compliance, example steps taken or proposed to inform managers of the employer's obligations under the agreement. What we see is happening is that we'll develop a tool that you can utilise to meet that obligation. On the issue of workload, the clause talks about engagement on workload and lists the type of information that may be relevant. It should be noted that the clause is expressed in terms of may rather than being prescriptive. And I'll acknowledge that these areas were pretty challenging for the reference group. But what stood out for us is that the concerns were not so much about the ideas, but a lack of confidence as to whether the other party could engage reasonably and responsibly. So just do understand that that is something of a challenge. But I'll make the point that workload issues currently come up frequently under this agreement. And in terms of the way that they come up, it is often with a degree of emotion rather than evidence. And one of the purposes for having a term like this is to try and get a shift so that these things start to those discussions are based more in evidence than emotion or feeling, as it were. Just really to help those discussions mature in a way that's not been possible previously. And in that point, those are the kind of things that are given as examples. The information could include the EFT, vacancies, personal leave, planned and unplanned absences, complaints relevant to workload, notifiable incidents, annual leave accruals and overtime. Different health services will have a different level of capacity in terms of accessing that information. For some, it will be push of a button, for some, it will be harder. It's not a requirement to hand those things over, but those are things that can indicate what's happening in terms of workload. We're trying to take those discussions to somewhere that's more objective rather than subjective, which has been the history, I guess, with this agreement. Moving to part 4, employment relationship and related arrangements. So we're going to cover transition to retirement, request to reduce ordinary hours, casual employment, fixed term employment, flexible work arrangements, consultation and redundancy, as well as associated entitlements. So I'll just make the point with regards to something like transition to retirement. What's interesting about enterprise bargaining is that ideally it should be forward-looking. But often it contains historical terms and it becomes difficult to address those historical terms. And for an agreement such as this one, terms accumulate over time. And for this agreement in particular, there are some terms that are different to those of other agreements. And part of the task in bargaining was to take a step towards orthodoxy where that was possible. So in this case, different elements of this issue were in different locations, and they were tangled up with other issues. What we've sought to do is consolidate that into a single term in a single place, like the one you expect to see under other agreements. And one of the points we always like to emphasise here is that transition to retirement, whether it's this clause or any other clause, is not notice of termination as such, but this clause has been amended and is more like the clauses that you find under other health agreements. This was the other part that was tangled up with the transition to retirement, a request to reduce ordinary hours. That's been separated out. And the term expressly states that it's in addition to and not in place of terms regarding flexible work arrangements. So the question that you'll ask, why distinguish clause 21, request to reduce ordinary hours, from a flexible work arrangement? There is overlap. A request to reduce ordinary hours under this clause 21 may be available in circumstance where an employee doesn't qualify for a flexible working arrangement. Similarly, the request to reduce ordinary hours contains restrictions that don't apply to flexible working arrangements. The entitlements may overlap, but they have to operate distinctly. And this was one agreement where we identified a range of potential compliance issues, and separating these ideas out helps us deal with those compliance issues. Casual employment. When the parties are bargaining, we often have to address changes from outside the agreement. And that's the case here for the casual employment clause. The Fair Work Act was amended with respect to casual employment. and that required an amendment to specify that the agreement term supplements any rights under the Fair Work Act, which provides for the conversion from casual to permanent employment in some circumstances. And there were other amendments too that were necessary for carers leave and compassionate leave. So these changes were made for the purpose of compliance with the national employment standards under the Fair Work Act. Fixed term employment, this has also been amended. And in terms of fixed term employment more generally, it's very much purpose driven. So broadly, the objective for employment within our sector is to maximise permanent employment wherever possible, but whilst acknowledging that there is a need for supplementary labour, whether that's in terms of casual or fixed term employment. It's also worth saying that the management of fixed term contracts is both something that can be contested. It can also be a risk for employers, specifically if they're not managed with precision, they won't be for a fixed term. In terms of what you see on screen, you'll note that the term has been amended to provide for additional details as to when a fixed term contract might be appropriate. Just to be clear, in terms of those examples, backfill for leave, long service leave, parental, to support flexible working arrangements and special projects, you don't have to use a fixed term contract in these circumstances. It's just that it can be a legitimate reason for the use of a fixed term contract. What's been introduced is a conversion term, and it talks about the fact that somebody can, in the same way that we're used to somebody converting from casual to permanent employment, the same question can come up here in terms of fixed term employment. As a general comment, one of the chief challenges for employers is time. Time is a really tricky thing for employers. You can enter into a fixed term arrangement for the right reason, but over time, the background circumstances will change, and what started off as an appropriate fixed term arrangement may no longer be the best mode of employment, and a person can raise that where things change. So it might be appropriate at the time, but it may not be the case after a period of time goes by. So what this does is provide an ordered mechanism by which to resolve changes that have occurred over time, so that the mode of employment can genuinely fit the circumstances. That's really the objective. The status quo is simply that that's an issue of dispute, but this provides a process. And also, a fixed term employment clause has been further amended to ensure that contracts are used for genuine fixed term periods. It talks about employers giving preference to ongoing employment over casual and fixed term arrangements where possible, start and finish dates to be specified where possible, the normal course of fixed term contracts to be 12 months. That's really in the form of a statement. It does not prevent a longer contract so long as it is appropriate to the circumstances. And it confirms that if you continue to employ someone after the expiration of a date, that the person will be permanent at that point. And that's generally how it works. And it's one of the key risks associated with fixed term employment. Clause 27, flexible working arrangements. I would describe this clause as a step towards orthodoxy for this agreement. In terms of flexible working arrangements, generally speaking, these are something that all parties support, and we certainly support them. They had been, as we understand it, a little bit more controversial under this particular agreement, at least historically. So there are amendments to the existing term, including a right to be represented, including by the union, in discussions about a potential flexible working arrangement. That's a common term within the health sector. And if you want more information on flexible working arrangements, I would recommend episode 189. And although it concerns nurses and midwives, it does have more general application. But by now you will have picked up that one of the key themes for this agreement is how to get towards a more orthodox setting. There are a lot of unique features of the medical scientists agreement, and that does continue. But over time, the challenge is how to make it more consistent with other agreements. Clause 30, consultation. This, of course, is an existing clause. This is an instance where the starting point is similar, but nevertheless different from other agreements. So some of the changes here, though, are directed at aligning with other agreements. Those include consultation is to capture those on workers' compensation to the extent permitted by law. Redraft of definitions to reflect current practices, and where a party believes that a delay in consultation is unreasonable, the matter may be referred to the Fair Work Commission for determination. I think with respect to consultation is something that's overrepresented in terms of disputes. A key cost arises from delays over consultation and disputes over consultation. So anything that can be done, and we would certainly recommend to members who are experiencing that delay to use an early reference to the Commission wherever possible. There is a reference there to position descriptions if relevant to the proposed change. The existing and proposed PDs of the affected employees will be given by the employer to those employees in the union. That's a change you'll see in other agreements, including the nurses and midwives agreement. Also, in terms of consultation, that first dot point there on screen is connected to the point about delay we were discussing before. Any concerns by an affected employee or their representative regarding whether the change impact statement is compliant will be raised as soon as practicable. In some instances, we've had suggestions that people have been at the last point and someone has asserted non-compliance and claimed that parties need to go back to the start. This is directed at preventing that from occurring. This slide also does emphasise that there are some unique terms regarding technology. My own view with regards to those technological components of the consultation clause is that generally covered by the standard clause, but I think their existence within this agreement reflects the particular history for employees under this agreement, and they were particularly susceptible to change arising from technological change. And once again, there is a podcast episode 213. Although it concerns nurses and midwives, it does have general application. Clause 30A, consultation about hours to rosters or work. Those who have seen enterprise agreements in this round for other groups will be familiar with this change. This clause is a compulsory term. It must be in the agreement. And it was part of the consultation clause, but we've separated it out. And the reason for separating it out is to make clearer when it actually applies. So this applies, there's actually a statement in the clause that says when it applies, where a change to regular rosters or ordinary hours of work, which may impact on the employee, particularly in relation to family and caring responsibilities, where it does not constitute a major change in accordance with subclause 30.2c. So what clause 30A requires is consultation without a change impact statement, just very quick, very direct, so that people are taking into account the impact on an employee. And it's for changes to rosters or to ordinary hours of work where it is not part of a major change under the other clause. That is not to say that any change about ordinary hours of work or rosters falls into 30A and not clause 30. That is not the case. If it's a major change and it involves rosters or hours of work, you stick with clause 30. But it's where it doesn't meet that major change and significant effect level that clause 30A has work to do. And just a key point, the way I put it on screen is that it requires a kind of consultation in circumstances other than organisational change. Redundancy and associated entitlements, again, this is an existing provision. And I just might ask people just to make sure that their microphone's not switched on. In terms of the amendments to the existing clause, it's similar to those in other health sector agreements, including where an employer is creating a new role that is substantially similar to the affected employee's redundant. Priority will be given to the redeployment of affected employees to the new positions, before considering applicants that are not affected employees. And also just a connecting of the dots, really. The relocation allowance will be based on the written estimate of the affected employee. Where the employer accepts the estimate represents the additional cost to the affected employee, the allowance will be paid as a lump sum. All those elements about a written estimate and the entitlement to a payment up to a certain limit, they are all in the current agreement, but that connection between the estimate and payment was missing. That gap has been closed. And there's also inclusion of a subclause in the Victorian Government's policy and public sector redundancy and entitlements as set out in the Public Sector Industrial Relations Policy 2015. Again, there's a podcast episode 214. Although based on nurses and midwives, it does have general application. Part 5, workforce management. This has some critical clauses: workload, planned and unplanned absences, advertising and filling of vacancies, exposure to hazardous substances, and the prevention and management of workplace bullying. For those who have had a chance to look at one of the podcasts that are relevant to this proposed agreement, you will have heard myself and the team make the point that one of the themes for negotiations was workload. And so these clauses are particularly critical. So clause 33 is an existing clause which has been amended. And I would add it's a really important term under this agreement. So the first thing you'll notice is that the clause looks very different from the one under the previous agreement. And that's because it's been fairly extensively restructured. The reason for restructuring goes to the point about the historical nature of agreements. Bits get added on from one round to the next, and then it starts to lose its logical thread. So from time to time, it's worth rewriting clauses just to make sure that they're structured as well as they can be. The previous clause, from our perspective, was a little bit chaotic, and we've tried to set it out in a clearer fashion. So the clause is restructured and amended. Work allocations will not result in an employee routinely working after hours, before or after rostered shifts, through meal breaks, or undertaking work at home, if not an agreed work from home arrangement. So that term work allocations is used, but really what it's trying to tell us is what is the sign that there is a workload issue. If somebody's having to work routinely additional hours before, after, through meal breaks, or working additional work at home, there's a workload issue. With respect to staffing, what it provides is that the employer to ensure that it's sufficiently staffed and resourced to enable each employee to perform all aspects of their role and position during ordinary hours, take their breaks, and take leave. You'll see there's a bit of a theme. There's a statement at clause 33.3 which states that all work performed must be paid. The employer will have regard to SHPA ratios when setting pharmacist staffing and workload levels. That was not something that was agreed in negotiations, but came out of an MOU process with the union and the department. Just in terms of what have regard means, it means no more and no less than that. It's not the same as saying a ratio applies, although that information is contained in an appendix within the agreement. I think one of the key stories for this agreement has been pharmacy. There are some key changes in terms of an input or an influx of EFT that is proposed, as well as changes as to when pharmacists can work as such, but we'll be touching on some of those changes as part of this presentation, but just really saying that pharmacy is a key theme. In terms of this clause 33, if I was to summarise what the key underpinning principle is, what the term requires you to do is to give ongoing consideration of workloads and the avoidance of set and forget. Workloads don't manage themselves. It's often the case that the right to manage is contested. But where there is fierce agreement is the right of an employer to manage workload. Now, there is a podcast which has been completed and is currently available on clause 33. I think it's episode 229, but you can find that now on our website. Planned and unplanned absences really goes hand in glove with clause 33. They're a matching pair. And the reason for having a term like this is to address workloads. It's a current term that's been amended. So clause 34 has been redrafted. Let's see. Just a question from Jason as to where we're up to. We're up to clause 34. Clause 34, planned and unplanned absences. Hopefully that syncing will work for you, Jason, but yeah, clause 34 is where you need to be. Just in terms of the reason, again, for redrafting, it'd been one of those clauses that had developed from successive rounds of bargaining. And as a result, it gets a bit unwieldy. It's good to restructure it and just to try and make it clearer. In terms of that first point, the existing clause talks about the obligation applying for certain types of leave. And the claim was to add additional types of leave to that. But really, that kind of approach, what it does do is it sacrifices logic. So we've taken a more direct approach, and rather than focusing on the type of leave or the reason for the leave, is to talk about the absence and the period of absence of 2 or more weeks. So obligations to backfill a planned absence arise if they're absent for a period of 2 or more weeks. Key terms are defined: backfill, same classification, time fraction, or if the replacement is at a higher rate, the higher rate. The absence includes approved leave, also includes work cover. A planned absence is one where it's known in advance that it will be for 2 weeks or more, even if it's with a mix of different types of leave. Somebody might take study leave and then annual leave. An unplanned absence for a shift worker or a rostered weekend worker, not known in advance, but for all others, it was not known in advance, it would be for 2 or more weeks. In terms of also the purpose of the clause, it does state that it's in order to maintain safe staffing and workload levels and appropriate clinical standards, stating that the employer will backfill an absence or where that is not possible, prioritise the work in accordance with this clause. Definitely a distinct order of preference there. Backfill, and backfill is defined, but if it's not possible, prioritise the work in accordance with the clause. In terms of a planned absence replacement, it requires that the planned absence be backfilled from the first day. That is when you know in advance it's going to be for 2 weeks or more. Again, though, if you can't, if despite best endeavours you can't backfill because a suitably experienced and qualified employee is unavailable, the work will be prioritised. In terms of unplanned absences, shift workers, it's consistent with the previous agreement, but for other employees, 2 weeks or more. It's consistent then with the planned absence. There is an expression in terms of preference. The preference be the backfill be from existing staff, that is making hours available to part-time staff. But within this, the employees under this agreement, there might be a smaller cohort of part-time employees than perhaps some other agreements. And which takes us to the issue of work prioritisation. This should be probably a statement of the obvious and reflect the current agreement, but the point that we've highlighted goes to transparency. So the employer will immediately prioritise work to ensure workloads of remaining employees are adjusted, or the work of the employee who is absent is not required to be undertaken, and that other employees are not unreasonably required to work overtime to complete their own work and that of an absent employee. But there is a requirement to have a written record, prioritise work arrangements provided to employees in writing, available for inspection at the request of the union. Again, goes to that point that the management of workload is an active thing and one that can be shown to be done. Again, this is an item where there is a podcast on this specific clause, and it's episode 234. I think, Maria, it was released at the end of last week. And is now available to members both through Yammer and through our website. So if you want to know more about Clause 34, there is a resource that's currently available. And advertising and filling of vacancies. Just a minor amendment there to say it includes changes to the vacant position. rather than consultation pertaining to whether the role is ongoing only. And that really came out of some disputes over the application of that clause, and those disputes are resolved with that amendment. Just an amendment here to clause 36, exposure to hazardous substances, to include other harmful substance that an employee may be exposed to in the course of employment. So just a minor amendment there. And clause 38, prevention of and management of workplace bullying. So this is quite a different looking clause, and we had some regard to the Victorian Public Sector Commission's materials with regards to managing poor behaviour in the workplace. That publication contains general principles that are applicable to health services, but also some really good practices. So we've got an expanded definition of workplace bullying that we've drawn from legislation. We've used material from a document called Managing Poor Behaviour in the Workplace, published by the Victorian Public Sector Commission. It's really good on process. The investigator and decision makers must act in good faith and free from bias. There was a claim to have the identity of the investigator agreed, but where we landed is somewhere very different. Provision that an employer, if they choose from the list of the Department of Health's preferred providers, then if you choose one of those preferred providers, just proceed directly. If you choose someone else, then you consult with the union prior to the appointment of that external investigator. So it's limited to external investigators. And when we talk about consultation, we're not talking about organisational change or change impact statements, but something that is very short because it's an OH&S matter and time is of the essence. If there is no response within the limited time frame, the employee can proceed with the appointment of that investigator. I think it's 5 days that they have to provide any feedback. I'll pause at that point just to see whether there are any additional questions on that first part of the presentation. There will be further opportunities, of course, to ask questions as we go, and again at the end. All right, not seeing any hands up or any additional comments.
Sorry,
yes,
Stuart, just Diana here from the Alfred from Pharmacy. Just a quick one around fixed term employment. In terms of parental leave, we're having more people choose to take less time for parental leave, so about closer to 6 months rather than 12 months. When you talked about fixed term employment, does that mean that my backfill has to be a minimum of 12 months, or it can still be a 6-month appointment to backfill that parental leave position?
Yeah. Thank you for that question. So there's no requirement that a fixed term contract, and when it says generally 12 months, that's really more intended as a cap, a suggestion that it's probably no longer than that, as opposed to shorter. So for something like parental leave, which is a great example, but other examples would be long service leave. You can utilise a fixed term contract if it's what you need to bring in a resource for a period of less than 12 months. That's not controversial at all. So if 6 months is what you need to fill that gap and provide that resource, you could do that for something like parental leave. You can do that with long service leave. But yeah, very much that reference is really intended to say, look, generally it's not longer than that. But having said that, there are circumstances where people are in research projects that might go for a couple of years. All right, if there are any other questions that come to people as we go on, please pop them in the chat and we will come to them today. And if we don't know the answer off the top of our heads, we will take them on notice. But for part 6, I'm going to hand over to Madeleine White, to Maddie, to take us through classifications, salaries, and higher qualifications allowances. Maddie, I can't help but notice that you focused on the money parts.
Yes, thanks, Stuart, and good afternoon, everyone. So as Stuart just mentioned, I'll be starting with part 6 of the changes to the current agreement. So the first change that we'll go through is just in relation to clause 39, which is management of high qualifications allowance. Obviously, as members will be aware, it's really important that the qualifications allowance outlined in our enterprise agreements reflects current and emerging applicable qualifications. I can never say that word. So really the amendments and the changes made to this clause is just to reflect the new qualifications that aren't currently captured in the agreement. So that is the inclusion of an entitlement to 7.5% of the employee's base rate as defined, where the employee has a Master's of Business Administration, Master of Leadership, Master of Education, Master of Law, or Master of Public Administration that is relevant to their role. The next change is in relation to clause 49, progression through pay points. So this clause has been amended, and it's really to reflect the clarification to reflect progression through pay points that recognises prior service. So the changes now will mean that employees will maintain their pay point and anniversary of employment for the purposes of progression through pay points where the service with another employer was in a grade or subgrade at least equal to or comparable to the grade in which the employer is or is about to be employed. And this is obviously subject to the allowable period of absence in terms of long service leave. So that allowable period of absence means the greater of 13 weeks, and that's inclusive of annual leave or 5 weeks, in addition to the total period of paid annual long service leave or personal leave, which the employee actually receives on termination or for which the employee is paid in lieu. I will now move to the changes to salaries and allowances. So as you can see on screen there is a 2% increase from 1st of December 2021 right through to 1st of December 2024. It's a 2% each year. There's also additional payments and changes, and those cover patients in bargaining, the annual skills and incentives payment, excluding psychologists, annual retention payment, psychologists only, and an increase to the top of band increment. So just going through those in a bit more detail. In addition to what I've just spoken about, the salaries are also to be rounded to the nearest 10 cents and allowances to the nearest 5 cents. The increased final year increment will be increased by 0.5%. The once-off patients in bargaining payments are provided at 2% of an employee's earnings between 1st of July 2021 and 30th of November 2021. The annual skills and incentives payments of $1,000 per annum between 2021 and 2024 for full-time employees in all classifications except psychologists, and will be pro rata for part-time employees. And then the annual retention payment will be provided for full-time and part-time psychologists each year, again, between 2021 and 2024, and the amount varies from year to year. So we'll be issuing further implementation material for these items, similar to other enterprise agreements that have similar incentives in the form of Q&As. The patients in bargaining payment members may be aware of and seen it in other enterprise agreements. The main change or difference, I guess, with this agreement, patients in bargaining, is that the payments are inclusive of shift allowances and penalty rates. So in the AHP agreement, they were exclusive. In this agreement, it's inclusive of shift penalties, Saturday, Sunday rates, public holidays, and overtime. So that's a really important key difference to be mindful of. But as I mentioned, there'll be further implementation material to come. Just on this slide, we're looking more at that retention payment. So that sets out exactly what the payments are. So for the psychologist classification, we'll receive an annual retention payment for 1st of November 2021, it's $1,500. For 1st of November 2022, it's $1,800. 1st of November 23 is $2,000, and 1st of November 2024, it's $2,000. Then the annual skills and incentive for all staff other than psychologists, it stays at $1,000 rate for 1st of December 2021 through the 1st of December 2024. So there will be more, I keep saying this, there'll be more information coming, but I guess something I just wanted to raise today is that the key important item is to bear in mind when looking at the retention payments is that these employees need to be subject to the current agreement, being the 2017 agreement, to be eligible for these payments. So that's just something to bear in mind at this point in time. Moving along now to some other allowances and wage changes, looking specifically at the medical physicists and clinical proficionists. The medical physicists allowance of 2.5% of the base rate of pay when appointed to clinically supervise a medical physicist registrar, and a clinical perfusionist, the alignment of clinical perfusionist salaries and inclusion of Austin Health and Melbourne Health in Schedule 5, the changes for those allowances. Moving on to everyone's favourite topic, being superannuation. Again, you're going to see some familiar terms in the changes to this agreement. The first being fund choice. So similar to other agreements in this round, the clause now allows for fund choice for legislative compliance. So that was an employer claim, and it's in line with the Treasury Laws, Your Superannuation, Your Choice Bill of 2019. The other key change here is parental leave and including unpaid parental leave. So the payment of unpaid parental leave will also include any payment in which the employee receives payments under the government's parental leave or dad and partner leave scheme. And it's applicable from the 1st of December 2021. The clause will contain specific calculations for the payment. So hopefully that'll provide some clarity on that amount. And really the rationale for the change is during the bargaining round was to address the retirement income gap. Moving to part 7, we'll be looking at the hours of work, shift work, employee rosters, a 10-hour break, meal and rest intervals, overtime, and on-call recall. Sorry, just I'm coming in onto my screen now, so that's providing a little bit of difficulty. So firstly, with clause 55, the hours of work. So the key change to the hours of work concerns an employee's claim regarding the pharmacist, as Stuart mentioned earlier in this presentation. As you would be aware, there has been no provision for pharmacists historically to work ordinary hours on weekends, and it's always been paid at the overtime rate. So that's going to be, we're going to start to see a change to that. The changes will take time, we're aware of that, but for us it was important that there be some shift to address what we say was an archaic restriction that doesn't represent how health services operate. So we're moving away from the prohibition to a position where pharmacists couldn't work ordinary hours on a weekend, and there is a distinction between existing and new pharmacists. So existing pharmacists can request, but can't be required. The employee can terminate that arrangement. And in terms of why an existing pharmacist might be willing to accept ordinary time rates rather than overtime rates, we had done some modelling during bargaining to show that for some, it was more advantageous to do the work at ordinary rates once weekend penalties, leave accruals, and superannuation are taken into account. And also it will provide certainty of access for the employee and certainty of supply for the employer. When it comes to new employees, they can be required to work weekends, but that's subject to the qualifying period and some further conditions. The focus for this shift is not about reallocating existing resources, but increasing resources and capacity for weekends. clearly, we acknowledge that this will require some further implementation material, but the key takeaway for us is that the change is coming.
What's the penalty rate for working on the weekend for the pharmacists then?
That's
Sorry.
a question, I think, from David as to the applicable penalty rate for working on a weekend. So
Yes.
the answer is it'll be the same as the other stuff.
So they'll
So
go
it's-
down. They'll go down to 50%.
Yeah, that's right. But they'll have the access to the leave, superannuation, and those things that the overtime doesn't attract.
Okay, and I would assume the casual rate would alter as well for weekends for pharmacists then?
I don't think there's any proposal to alter the casual rate. So the casual rate remains as it is. But I'll take that on notice just to confirm that if that's helpful, David.
Thank you.
No worries.
Perfect. So just continuing with the hours of work, onto clause 55. The clause has been amended, and it's amended so summertime clause to clarify that when a shift occurs over a daylight savings period, where the time changes, the employer is paid for hours worked as opposed to time on the clock for consistency with other Victorian public health sector agreements. The key point here is that the change to summertime is directed towards achieving consistency, and there will be there's further information in VHIA podcast 235. Moving along to clause 56 and shift work. So really the amendments made to this clause were done with consistency in mind. Different cohorts of employees in the 2017 agreement had different shift work rules, being able to streamline rostering across cohorts, resulting in an equitable spread of workload was desired. So historically, obviously, pharmacist rates have been different as they were unable to complete those ordinary time hours on weekends. And as that was bargained for in this round, it was therefore logical to have other penalty rates aligned with other cohorts. And to that end, the existing clause was amended as on screen. So the alignment of the pharmacist shift work penalties with all other professions. As of 1st of December 2022, morning shifts for pharmacists will be aligned to the rest of the agreement. There was the introduction of a night shift penalty for pharmacists, and that's again in line with all other cohorts under this agreement. The afternoon shift allowance will be increased from $28.30 to $50.90. The distinction between a permanent night shift and night shift will be abolished, and the new rate for night shift will be $92.40. The change of shift allowance will be increased from $45.25 to $65.55. And there will be the insertion of penalty rates for pharmacists who work ordinary hours on Saturdays and Sundays.
So the next clause we'll discuss is clause 57, and that's employee rosters. So the changes that have been made are equivalent to those made under the nurses agreement. And one of the issues that emerged within the nurses implementation space has been around how to calculate any back pay arising from the 8 to 14 day change. So we would recommend that members take steps to ensure that they have a capacity to back pay now. Further to that, changes made provide employees certainty with respect to rostering arrangements and to recognise the disability associated with roster changes within 7 days. Continuing with clause 57, employee rosters. Those of you that are familiar with the rosters clause will know that it has some significant restrictions on how people can be rostered, including, for example, the number of weekends that can be worked, There is an amendment that facilitates different rostering arrangements by agreement. For example, an employee who wants to work more weekends to maximise their income can now do so. So we've just summarised what I've just discussed on the slide there. Continuing again with employee rosters, there's the introduction of a 10-hour break between ordinary shifts, and that's an amendment. Currently, it's an 8-hour break. So there was a move to 10-hour maximum break between ordinary shifts rather than 8 during this round of bargaining. This change is really about fatigue management and ensuring that rosters are designed with a reasonable period between ordinary shifts. If it can't be accommodated, there are penalties equivalent to those applying when an employee doesn't get a 10-hour break after overtime. There is an opportunity to consult to transition, but we expect that to have little application in this instance. And just more information that we've got available for members is that there's a podcast around this, and it's podcast episode 235. Clause 57A goes into further detail in relation to a 10-hour break not given. So the key point here is that clause 57 has been amended to move again from that 8-hour to 10-hour break between ordinary shifts. And where for urgent operational reasons, a 10-hour break is not provided between ordinary shifts, an employee will either be released from duty without loss of pay until the employee has had the 10 consecutive hours off duty, or be paid at the rate of double time until released from duty for such rest period, where the employee is required to work without a 10-hour break on the instructions of the employer. A further key point here is that this principle reflects the approach to resuming work after overtime. And the clause comes into effect when the first roster is posted following 4 weeks from the date this agreement comes into operation. Another new term is clause 57B, 10-hour break, and this is the consultation and the transitional arrangement. So as clause 57A does not take effect immediately, this clause acts as a support to recognise the transition period where an employer may wish to commence the change from an 8-hour minimum to a 10-hour minimum break between ordinary shifts. And so what this clause does, it includes the 10-hour break, is consistent with the rostering protocols at clause 57.4, is equitable in overall sense, having regard to the overall needs of the employees, including family responsibilities. And once the above roster is implemented, the terms of clause 30, consultation will then apply. Moving on now to clause 58, which is in relation to meal and rest intervals. Meal and rest intervals have been a consistent theme across negotiations this round. And the key changes in relation to this agreement really is about the pharmacists. Whilst the agreement still provides that pharmacists are entitled to a meal break of not less than 45 minutes and not more than 60 minutes, the clause now does provide that by agreement, a pharmacist may agree to a 30-minute meal break. Similar to the shift allowances, the amendments were made to align this cohort to the rest under the agreement. The clause further provides clarification as to what a meal break means and is directed to meaning that a meal break is where the time is the employee's own. Moving to clause 59, which is overtime. There was a decision in the Fair Work Commission that concerned the calculation of overtime for casuals in the Health Professionals and Support Services Award, and as such, the amendments reflect the changes under the modern award. So what this is that in excess of ordinary hours on any day, 187.5% for the first 2 hours, and 250% of minimum hourly rate thereafter will be payable. And outside the spread of 12 hours from commencement of rostered period of duty, 250% of the minimum hourly rate, And on public holidays, it's 312% of the minimum hourly rate. For pharmacists, there's also the removal of overtime for pharmacists on weekends and the deletion of clause 58.5. And the key point we wanted to make in relation to this clause is that pharmacies change is there to make way for an employer to claim regarding weekend ordinary hours for pharmacists. Clause 60 discusses on-call recall. The amendments to the on-call recall are as follows. On-call work allowance for all employees except psychologists, science directors and deputy directors have a standard rate in Schedule 2. Psychologists will receive an on-call allowance as a percentage of their weekly base rate unless the rate in Schedule 2 for all other employees is more beneficial. And pardon me, scientist directors and deputy directors to receive a higher allowance, 10% of a weekly wage when required to be on call outside of ordinary hours. And this is commonality and reflects the increasing workload as a result of being rostered on call. Recognising that not all cohorts could receive the same rate, as they would have been worse off, bringing them in line with the medical physicist rate and would have been a reduction in their entitlements. But the overall intent of that clause was to bring all cohorts in alignment. We'll move on to part 8 of the presentation, which is leave of absence and public holidays. We'll be discussing annual leave, excess annual leave, personal carers leave, compassionate leave, long service leave, breastfeeding facilities, parental leave, professional development leave, reimbursement of professional development expenses, sabbatical leave, and leave to engage in emergency relief activities. So firstly, we have clause 61, annual leave, and the clause was amended to include a term which allows for annual leave to be taken in part-day periods, provide that annual leave shall not be unreasonably refused, make minor changes to language around payments on termination, and just some amendments to the capitalisation. Clause 62, excess annual leave, again, is an amended term. The new clause was inserted to replace previous terms such as excess annual leave management clause consistent with the Health Professionals and Support Services Award 2020. Excess leave accrual is defined as more than 10 weeks of paid annual leave or 12 weeks for shift workers. An employer may direct the employee to take the leave in one or more periods if there has been a genuine attempt by the employer to reach an agreement with the employee, but no agreement has been reached. Where an employee has genuinely tried to reach agreement with the employer, but no agreement is reached, the employer may give notice in writing to take one or more periods of paid annual leave. And the employer will have regard to the obligations contained in clause 34 of this agreement, which includes backfill. Clause 64, personal carers leave, was amended to clarify that an employee's paid entitlement accrues progressively over a year of service and accumulates from year to year. Years of service definition was inserted to recognise prior service for the purposes of determining the personal leave accrual. And the key point for this clause is that the amendment means an employee who is a new employee but has recognised prior service will accrue personal leave at a rate that reflects that service. So an example is where a new employee with 3 years recognised prior service would accrue at the rate of 136 hours and 48 minutes per year rather than 121 hours and 36 minutes. Clause 65, compassionate leave, was amended to provide the ability to access compassionate leave where the employee or their immediate family or household experienced pregnancy loss after 20 weeks gestation, and that was consistent with the changes with the NES, and the ability to access compassionate leave where the employee or their spouse or partner experience a pregnancy loss after less than 20 weeks gestation, again consistent with the NES. So the real key point for this clause is that the NES changes came into effect and the changes made to this clause are reflective of the legislative changes during the life of the previous agreement. Clause 67 is long service leave. So a common claim during the bargaining round has been to align access to long service leave provisions to the State Long Service Leave Act. This is recognising the changing landscape in the workforce and recognising that employees may not be staying with the same employer for that 10 to 15 years. So similar to the Nurses and Midwives Enterprise Agreement, access to long service leave is to be introduced progressively. So we've got a pro rata long service leave from 7 years to be introduced from 9 years from 1 July 2021, 8 years from 1 July 2022, and 7 years from 1 July 2023. The existing transition to retirement clause has been moved to Part 4, and that's without a change to entitlement to ensure clauses are located in the most relevant location within the agreement. Clause 70.5b also provides long service leave periods that count towards continuous service. Excuse me. For further information, we have filmed podcast episode 238, which goes into further detail about the changes for long service leave. Clause 69 refers to breastfeeding facilities, and these amendments were made providing for a reasonable paid break to express breast milk, a provision of a comfortable space shielded from view to express and or breastfeed a child, and availability of appropriate refrigeration. Clause 70 discusses parental leave, and these terms will look largely familiar as they align with the Nurses and Midwives Enterprise Agreement. The clause was amended as follows. So gender, there was removal of gender-specific references, including maternity leave and parental leave. Paid parental leave, there was the increase to the paid component for primary carer leave from 10 weeks to 14 weeks. And paid secondary carers leave from 1 week to 2 weeks. There's the superannuation payment during periods of unpaid parental leave and when it's to be taken. So paid parental leave must be taken contemporaneously with the birth or placement of the child or children. The qualifying period is now after 6 months continuous service. Service has been expanded. The definition, of service was expanded to include service with other public sector employers. There's the early return, and employees' request to return from parental leave early would not be unreasonably refused. And there was changes for NES compliance. Key point here is whilst many of the outcomes are consistent with the other health agreements, there are still some terms in the agreement that are unique, including with respect to returning to work, which is clause 70.12. Clause 73, professional development leave, was amended. So the accumulation will be up to 2 years, which is similar to the allied health professionals. And regular and systematic casual employees may apply for professional development training, although there's no quantum specified. The inclusion of a casual employee receiving professional development allowance has been added to recognise that these employees also work in clinical areas, and it is important to have them suitably trained. So the professional development work must be directly relevant to the casual's work that they undertake for the employer. So we have a new term at clause 75, which is the reimbursement of professional development leave expenses. So the reimbursement of all reasonable expenses incurred in connection with the approved professional development leave. So this could include instances such as registration, travel, and childcare. Applications will also include time spent travelling to and from the learning activity. Clause 76 discusses sabbatical leave, and this clause was amended to recognise service within the public health sector for the purpose of sabbatical leave rather than service with the current employer. This is relevant when an employee becomes eligible only for sabbatical leave. We then have clause 79, which is leave to engage in emergency relief activities. And there was a minor amendment to the existing clause, providing that any entitlement under this clause is in addition to any entitlement to unpaid community service leave under the NES. The term is different to that found under any other health sector agreements. Do we have any questions in relation to that section?
Maddie, just in terms of questions, where can members post their questions just for reference?
Yes, so we have Yammer, so that's a really good resource for members to be able to post any questions onto that site. And then we also have the query, the query team inbox email that's accessible to members as well.
So that's query at vhia.com.au. Under Yammer, it's either the general feed or there is a medical scientists page, and we'd encourage members to share their questions through that format also. Thanks so much for that, Maddie.
Great, thanks, Stuart. So I'll hand over to Maria now to continue.
Thanks, Maddie. So I'll be continuing on with Part 8, leave entitlement. So in this part, we'll cover public holidays, cultural and ceremonial leave, special disaster leave, absences on defence leave, and gender transition. So the first slide in relation to public holidays, so the key changes that we have is the inclusion of the grand final day within the list of recognised public holidays. So this has been enshrined within the agreement now and is not based on additional days being gazetted by the government. We also have a mechanism to facilitate substitution of public holidays by mutual agreement, and that would be on the basis of an employee and employer mutual agreement. So this is to align that entitlement with the National Employment Standards. And the last change that we have is an increase to the minimum recall period. So this is increased from 2 hours to 3 hours, and that's for consistency with our other public sector agreements. So the next slide for cultural and ceremonial leave. So we've inserted a new term which deals with consideration of requests to substitute public holidays for days that occur during NAIDOC week. So where an employer receives a request under this public holiday substitution clause to swap the public holiday for a day in NAIDOC week, the employer will consider all the circumstances, including any reasons identified by the employee with respect to the requests and the operational requirements of the employer. So an employer will not unreasonably refuse a request to substitute a public holiday under this clause. So the next slide, we have special disaster leave. So this clause is very similar to our other public sector agreements and will provide for up to 3 days per annum for employees who are unable to attend work due to a special disaster. And this is a paid leave entitlement. So the terms around how special disaster leave is paid is similar to all the other public sector agreements, and it's only available where an employee doesn't have personal leave or carers leave available. So the next clause is regarding absences on defence leave. So clause 84 is also a common clause within the major agreements, and it provides for a wage top up for employees who are defence reservists and are absent on service. So gender transition leave is a relatively new clause and entitlement within the Victorian public sector, and not all of the major agreements will have this term. So it has been implemented already as a new term within the mental health agreement and is also in this medical scientists agreement. So we anticipate that in the next round of negotiation, it's likely going to be replicated within the other agreements as well as a minimum entitlement. So under this clause, an employee, other than a casual employee who commences living as a member of another gender, is entitled to gender transition leave for the purpose of supporting that employee's transition. And that leave will comprise of 4 weeks, so 20 days of paid leave entitlement, and that's for essential and necessary gender affirmation procedures, and up to 48 weeks of unpaid leave. So the next part, we move on to part 11, which is clinical supervision of psychologists and other matters. So the first slide is clause 94, psychologist supervisor training. So this is a new clause which has been inserted, and it allows for where a psychologist meets the PBA requirements, that they will be approved to undertake supervisor training upon request. So the employer will be required to pay reasonable costs to undertake that PBA approved supervisor training course, with reasonable costs being defined within the agreement as including but not limited to course fees and time release without loss of pay to undertake training. Applications that are made under this clause 94 will need to be responded to within 14 days. So the next clause we got, clause 95, clinical supervision of psychologists. So this has remained fairly similar. However, we've moved some of the terms from Schedule 3 under the classification descriptors to clause 95 for clarity, and this is with respect to the clinical supervision requirements of grade 3s. And then the main addition that we have is in respect to external supervision requirements for grade 6 psychologists, which is a new classification and will allow for supervision to be undertaken by someone external to the organisation, as opposed to the rest of the structure, which is supervision by someone who is within a grade higher than the employee. The clause 96, no restraint of patients. So as the title suggests, essentially a psychologist will not be required to physically restrain a patient, except in circumstances where there's immediate duty of care to maintain safety. And nothing within this clause would affect the role of a psychologist in participating in any sort of de-escalation or code responses. The next slide, 97, is to do with amenities, and this is providing a psychologist, as far as reasonably practicable, access to an office space, technology, including a computer and or laptop, telephone, mobile phone, and storage facilities, and also clinical spaces to see patients. This provision of amenities will be appropriate having regard to the work that's performed by psychologists, including the need for any sort of privacy in the clinical or professional activities. As far as reasonably practicable, there's also a term within the agreement about not having employees do hot desking, and as an alternative, it's suggested that employees would be able to find another space to undertake those clinical activities or work from home if able to. If working from home, employers are to provide the necessary equipment required to undertake those activities, and that's also the same for any sort of telehealth that's undertaken from home. And when refurbishing or constructing, consider and consult. So if an employee raises any issues with the amenities, there is an obligation under there for the supervisor to consult with the employee, and if they're not able to meet the request, that there will be things considered to mitigate the impact. Next slide is regarding clause 98, the Royal Commission Working Group. So the new Royal Commission Working Group will be set up between the parties as soon as reasonably practicable, but in any case no later than 1 month after the commencement of the agreement. The working committee will consist of representatives from the HSU, the Department of Health, VHIA, and any other members as invited by the committee. So the objectives of that group are to identify any amendments to the agreement that are necessary to give effect to those Royal Commission recommendations, to seek to reach consensus on any necessary amendments to the agreement, to seek to address and resolve any significant to seek to address and resolve any significant industrial issues that are associated with the implementation of the Royal Commission recommendations and proposals and the process of legislative changes, and considering and responding to any specific requests from the Department of Health. So the next part, we'll move on to the schedules. So the schedules are listed on screen. We'll go through them together. So the first one we'll talk about is Schedule 3, which is our classification descriptors and higher qualifications allowance. So the first change here is for principal scientists. So these have been amended to include respiratory, sleep, neuroscience, and vascular laboratories, and include cytology and histology as separate disciplines in the anatomical pathology, molecular hematology, and molecular biology, pathology, and cytogenetics. It's a bit of a mouthful, but essentially just extending the areas of which a scientist can work. And principal scientists will not be required to be appointed, and will be at the discretion of the health service. So that that's just an important note in there. We will also have revised pharmacy grouping to reflect the expanded pharmacy services at clause 7.11. A medical physicist appointed to clinically supervise a medical physicist registrar will receive a new allowance of 2.5% of the base rate as defined, and that would be the medical physicist supervisor allowance. Where the chief physicist at Barwon Health, which is a unique classification to that employer, is appointed clinically to supervise, they'll be paid an allowance of 2.5% of the grade 1 year 1 medical physicist rate. So continuing on with Schedule 3. So there's been amendments to the descriptor for dietitian and senior clinician grade 4 by adding except for dietitians who work as the sole dietitian in a health service or campus, in clause 3.7 of Schedule 3. The references to mandatory experience have been amended to indicative measures to increase flexibility. There's also a deletion of clause 5.1 of the medical physicist classification structure. And this was done to remove the limitation for medical physicist classifications to only exist within certain employers that are covered by the agreement. So in terms of the other changes, so we had expansion of examination leave to grade 1 psychologists to facilitate their registration. There's expansion of grade 2 psychologist and formalisation of existing internal arrangements for registrar attendance to training programs. So then on the next slide, so there's also a new clause facilitating psychology grade 2 to grade 3 progression by request, where that employee has endorsement from the PBA in an area of practice, has a minimum of 5 years experience as a generally registered psychologist. So this is at a grade 2 equivalent higher, performs complex clinical work of a psychological nature as part of their normal duties, and is a PBA approved supervisor. So of note, there is the additional mental health requirement at clause 11.2 of Schedule 3 will still apply. So this states that only psychologists who hold an endorsement from the PBA in clinical psychology, forensic psychology, or neuropsychology shall be employed at grade 3 and above in mental health services, provided that psychologists employed in that mental health service area. So in these circumstances where an employee was transitioned from a grade 2 to a grade 3, it's assumed that they possess advanced knowledge and skills such that an application for that progression is warranted. The response from an employer will need to be completed within 28 days of receiving that request. And you can only refuse a request to move to the grade 3 role where there's no grade 3 work available. So any sort of budgetary constraints or where a vacancy does not exist will not be reasonable grounds to refuse a request. Where progression occurs, a psychologist is required to undertake grade 3 work, and any sort of disputes can either be resolved through that dispute resolution panel procedure or escalated through to the panel. So for the next slide, there's also an introduction of Director of Psychology at the grade 6 level, and they will be appointed at the following health services: Alfred Health, Austin Health, Ballarat Health, which is now Grampians, Barwon Health, Bendigo Health, Eastern Health, Melbourne, Monash Health, Peninsula, Royal Children's Hospital, Southwest Healthcare, and Western Health. And I believe Northern Health as well, but for some reason they're not on that list on screen. The new clause will increase opportunities for grade 3 psychologists to work in areas that don't have necessary endorsement but could work based on scope of practice. For more information regarding those changes, we also have a podcast available, which is number 244. For Schedule 4, there's only very minor amendments to cross-referencing and then a deletion of 6A. A substantive agreement is more beneficial, and this was to do with long service leave entitlements that were preserved. And for those long service leave periods to be taken in instalments of no less than 1 week. Schedule 5, which is related to Alfred Health, Austin Health, and RMH for the clinical perfusionists. So there's minor redrafts to provide appropriate cross-referencing and capitalisation. Austin Health and Melbourne Health will join Schedule 5 as well. So they've been included in that list. For Schedule 7, this is to do with the insourcing and outsourcing. So previously, Schedule 7 was specific to only 3 health services, and that was Melbourne, Northern and Western, and containing terms that were largely specific to a particular event. So now we have a small number of the previous terms regarding superannuation, which have been retained and continue to apply to those 3 health services. The balance of the term applies to all employers and contains terms regarding insourcing and outsourcing, and these will cover off matters including offers of employment, recognition of service, transfer of leave balances. So as a key point, so these outsourcing terms are consistent with the state government IR policy, and the insourcing term reflects the insourcing MOU provided to health services last year. Schedule 8, Royal Women's Hospital, Royal Children's Hospital, General Employment. So there's amendment to existing schedule to remove the definitions, which are no longer used throughout the clause. A deletion of long service leave subclause as the general terms within the agreement are now more beneficial, and a minor redraft to correct capitalisations and cross-references. Schedule 10, St Vincent's Hospital, and the amendment was to remove the long service leave subclause as the general terms of the agreement became more beneficial, and minor redrafts. Schedule 12 is to do with additional consultation and redundancy associated entitlements, and that will apply to the employers on screen. So again, minor redrafts, clarification that in the case of any consistency with clause 30 and 32 of this schedule, the more beneficial entitlement would apply, and redraft to correct the capitalisation and cross-references. There's been a deletion of terms which were less beneficial than the general terms under the agreement, and that's specific for Eastern Health, Alfred, Peter Mac, Royal Victorian Eye and Ear. Salary maintenance, so So we've got Schedule 2. Oh, so there's a salary maintenance change and redeployment as well, which were deleted within that entitlement because they didn't need to be within the agreement anymore. Other schedules, so Schedule 14, 15 and 16 are new additions to the agreement. So Schedule 14 is the inclusion of the template claim form for professional development expense reimbursements. Schedule 15 is just the inclusion of a rostering protocol exemption agreement. 16 is the insertion of the SHPA ratio guidelines, which there is a small drafting error with the SHPA ratios within the actual official copy of the agreement, which we will have copies on our IR page that you can get the completed version of those ratios. The next part is regarding the MOU. So the MOU is separate to the agreement, and the first part looks at the pharmacist appointments. So there'll be an additional 200 EFT of pharmacy positions that are allocated over the life of the agreement. That initial claim or the initial aim of those allocations is to increase the EFT numbers of pharmacists across public health to better align with the SHPA ratio levels, and where there's workload issues, the pharmacy service level performance it will be most in those acute areas. It is proposed that the appointment of roles will occur progressively, with 50 EFT to be recruited in each year between 2022 to 2025. Health services have already participated in a survey to ascertain the need for additional EFT, and this will inform discussions between VHIA department and HSU in relation to those final allocations. The HSU has agreed to a lesser number of additional EFT in the expectation that its claim for SHPA ratios will become an enforceable provision of the next EBA. And the parties will develop an agreed template to track the appointment of roles. So employers will need to advise the HSU of each pharmacist appointment to those funded positions within this arrangement, including the commencement date, time fraction, grade, and service location of each appointee, and notify the HSU on a quarterly basis of positions funded through this arrangement that remain unfilled, including the reasons why. VHIA will engage further with health services regarding implementation process. For ordinary hours of work, to support the implementation of the additional pharmacist EFT listed above, the parties have agreed that the proposed new agreement will allow the pharmacist to be rostered ordinary hours on weekends in accordance with the relevant agreement provisions commencing from 1 July 2023. So this is a big change from the current agreement, which provides for overtime for weekend shifts. So there will be that transition occurring in July 2023. For psychologists, so the MOU provides an additional 200 EFT of psych registrar roles to be allocated over the life. Sorry, that's not 200. It provides for an extra 75 EFT per annum for these mental health psychology roles, and an extra 10 EFT per annum of the allied health, so non-mental health psychology registrar roles. The implementation of that additional positions are currently underway. So there's currently some discussion about that. And the allocations for the mental health positions have been finalised. With respect to the 10 EFT of non-mental health roles, we sent out on the 30th of September Bulletin 2803 requesting expressions of interest for employers who hadn't been involved in the mental health allocation discussions. The response for the EOI process were due on Friday the 14th of October. VHIA will be engaging with VPA over the coming weeks to discuss the allocations of non-mental health roles. We anticipate this process will be finalised by the end of October or early November. For Directors of Psychology, so Director of Psychology Grade 6 is to be appointed at each of the health services that are listed within the MOU, and they're also covered off within the agreement. And likewise, this also applies for the Director of Psychology Grade 5 positions. So continuing on for the MOU for psychologists, the MOU also provides for the allocation of psychology educator roles within the listed health services. And there are both grade 4 and grade 5 positions that will need to be appointed to. VHIA will engage with the affected health services to track that implementation progress. And lastly, for the other items contained within the MOU, we have so the Department of Health will, over the life of the agreement, work with Barwon Health and St. V's to ascertain their needs to provide assistance with regards to recruitment and retention of clinical perfusionists. So that'll be a work in progress over the life of the agreement. And then in terms of reproductive health leave, any future decisions by the government to introduce a policy in this space is to be applied to employees covered by this enterprise agreement and will be incorporated as an entitlement of the future enterprise agreement. So that brings us to the end. Is there any questions?
Maria, where can people post their questions?
So they can post their questions on Yammer.
So please, we would encourage members to post questions to Yammer or to send them through to the query team at query@vhia.com.au or to email us at medicalscientistsEBA@vhia.com.au. But please send in your queries with regards to implementation. Just a reminder, there is a reference group for this agreement, which has continued to meet with a particular focus at this point on implementation. And when this video is posted and available, we'll repost a list of the current available implementation resources. Thank you, Maddie, and thank you, Maria.